Good afternoon and welcome. This is the law. It's your legal lights, it's your health law. And last week we promised you that we'll bring you a part 2 of our discussion on whether or not the OSP has power to prosecute influence peddling. The OSP says Ghana does not have laws on influence peddling, and that's the reason it is unable to prosecute Charles Adu Boahen, who was caught by Anas Arameyao Anas in an investigative piece and was forced to resign, I suppose, or was he sacked by the president? We'll be right back. I'll introduce my guest to you. You're welcome back. This is the law. It's your legal lights. It's your health law. Now, for those of you who are just joining, we are dealing with part 2 of the discussion we began last week, the education we began last week, whether or not the OSP can prosecute for influence peddling. And we hosted the OSP last week, and they insist that Ghana does not have laws for the prosecution of people who engage in influence peddling. Is that position correct? We have other lawyers who have some other views. So we will test those other views to see whether or not the OSP was wrong when it said that it was unable to prosecute Charles Adu Boahen, former Deputy Minister of Finance, because there is no such offense created under Ghanaian law. But before we go on, we will get to our Law 101. Well, for a while, we have not done the Law 101, but let's do it today. My guests who are joining me to do this discussion this afternoon are Dr. Justice Srem Sai. He is with Praetorium Solicitors, and he's a senior lecturer at GIMPA, the GIMPA Law Faculty. Is it law school, law faculty? We still fight about that. Okay.
Faculty.
Law faculty. There's only one law school, yeah?
Yeah.
Because that fight with the University of Ghana, I think the University of Ghana will always win that fight. Mm-hmm. There's a law school in the University of Ghana, and there is a school of law at Makola and its other satellite campuses. Also here is Martin Pebu. He is with GT Legal Africa, and he's a rights activist. Martin, thank you very much for making time to join us.
My pleasure, Sam.
Right. So we begin with our segment where we get our guests to give us 2 minutes of their views, comments, which is, of course, professional legal opinion on either a provision of law, the Constitution, or some latest development in the legal sphere. As you are aware, the Supreme Court has given a judgment and has struck down Section 13(2)(h) I and II of the Companies Act 1992 as being inconsistent with Article 19(2)(c) of the 1992 Constitution. This was a judgment in a constitutional matter filed by a lawyer, Derek Edujemfi, who prayed the Apex Court to inter alia, among others, delete, expunge, or strike out those subsections of the Companies Act for being unlawful, null and void. What do our guests have to say about it? But okay, let me just continue reading. According to him, those subsections, 2HI, 2HII, 2AI, and IC, among others, of Section 13, 172 and 177 of the Companies Act are unconstitutional and violate the principle of fair hearing, among others. As such, the Supreme Court, in its wisdom, granted his first two reliefs, thus striking out sections 13HI and II of the Act as being in contravention of Article 19(2)(c). So, let's get the views of our guest on the potential implications or whether this is good or it is not, as far as they are concerned. What do you say? I'll begin with Justice Srem Sai.
Yeah, thank you very much, and good afternoon to your viewers. I think when you look at the purpose behind the provision is to ensure that only persons who don't have questionable character would be allowed to manage companies, right, or take such responsibility, because
as directors.
Directors,
okay.
Yeah. So companies really are the directors. Because as we know, the company cannot act by itself. So the directors are the embodiment of the company. They do everything that companies are supposed to do. So the intention behind the law is to make sure that only people with valid, solid integrity could hold that position of directorship. But the question is, why would you put someone who has been accused of, a crime on a list where he cannot, enjoy the other rights that people who have not been accused are enjoying? And I think that is the actual purpose behind the provision in the Constitution, which says that you are innocent until you are proven guilty. What it means is that until your accusation has been proven, and has been proven in accordance with the standards of, criminal law,
yes, proof
beyond reasonable doubt, you shouldn't suffer any disability which will be placed on you. And I think we may have different views about the policy rationale, but I think we have to weigh the two options. Are you going to deprive people of their rights and therefore allow people to, officialdom, to abuse the right of people? In other words, so for example, someone can just accuse you, start prosecution, if the actual intent is to not allow you to be a director of a company.
That's right.
And we know this country and how our criminal justice system works. It could take years for you to be acquitted. And then after that, you might have suffered losses, either of integrity, either of money and other financial. So we need to weigh that against what we are trying to protect. So in my view, I think the decision is actually in line with the general jurisprudence on criminal law as to what will constitute.
In the Constitution, for example, it is provided that to be an MP or to be some other public office holder, you must qualify first as an MP. Yeah. And to qualify to be an MP, you must not have had, been convicted of a criminal offense hanging on you. Yeah. But they decide in the Companies Act, in the new way we have decided to go about it in 2019, that we don't even want you to be a person who has been charged, you've gone through trial, and you've been found guilty. For as long as you have been charged with a criminal offense, we think you should not be fit to be a director of a company. And this is Parliament. They should determine what the law should be.
Yeah, but the Supreme Court actually is the authority that determines what the law should be. So we are weighing, here what we are doing is that we are weighing an act of Parliament against the provisions of a constitution. And obviously, we know that the provision of the constitution will stand while the act of Parliament will fall.
That's
and
right.
The proper authority, as we know, it is exclusively the province of the Supreme Court to tell us what the law means. So in the case of this clash, it is foregone conclusion. Parliament's act must fall for the constitution to prevail.
If you read Dennis law, it said that on the part of the Attorney General, it argued that the Companies Act, which came into force in August 2019, introduced several new features. Notable among them is the restraint and disqualification of certain persons from holding the position of director of companies except with the leave of the court. The Attorney General thus argued that this new provision, having been enacted into law by Parliament pursuant to Article 93(2) of the Constitution, is sound. Additionally, the Attorney General impressed upon the court to adopt the purposive approach to interpreting the sections in contention, stressing that it is not a novel piece of legislation because institutions like the Bank of Ghana have been applying same by disqualifying directors. However, the Supreme Court, in the judgment, upheld the applicants' application and granted the first two reliefs, holding that it was unconstitutional to require a person so charged with a criminal offense within the stipulated time to deliver a statutory declaration to that effect, and so disqualifying them while they have not been proven or pleaded guilty. Martin.
Yeah, so with what the two of you have said, I have to just say I concur, right? Yeah, because you've exhausted it, really. You've exhausted it. Okay, maybe I can add a few words. So, Article 19, Clause 2C is clear, right? A person is innocent until proven guilty. So, what in God's name would move our parliament to seek to start punishing somebody who has not been proven guilty in a court of law? That's it. That's it. What would move Parliament to start punishing somebody who hasn't been proven guilty? And that's
if you want to be a director, all they are saying is that if you want to be a director, you should not have anything criminal hanging on you. So there should not even be an accusation of crime on your neck. Once you have been charged, then that's it.
Oh, I like the way you've repeated it. It's reminded me of this Julius Caesar. What is it? The wife's, Caesar's wife standard. Oh, so no accusation at all. You remember in the book, Caesar ended up divorcing his wife because there was a charge of adultery against her, even though it hadn't been proven by. He said that his wife should not be accused of adultery, right?
Should be beyond reproach.
Exactly. Oh, that's too much. Then Parliament itself will be empty. As you stated, if you look at the constitutional provision, the parliamentarians say even those offenses that disqualify them, they say after 10 years, you're eligible to stand to be a parliamentarian. Right. That's those offenses involving moral turpitude, stealing, and all those ones. It says the limitation or the disqualification is for 10 years, right? After 10 years, it's lifted, and then you can stand for to be a member of parliament. Okay. So it tells you that in our laws, a man cannot just be judged by one conduct. No. So it's right that the Supreme Court struck down those provisions because a person is innocent until proven guilty. If you want to go by Caesar's wife's test, the Parliament itself will soon be very empty. It will soon be very empty.
All right.
And let me make a quick comment. You see, there is something that I've been observing over a very long period of time, where attorney generals have held this position that every case that is brought against the state, they have to defend it no matter what. It should be possible for an attorney general who is the custodian of the leader of the bar to go to court and say, I agree with the plaintiff on this issue, and then the matter will be settled. Instead of every day arguing with every point, no matter how strong you just come in. The fact that you're a defendant does not necessarily mean that you should always file a defense. Sometimes you just agree with the person, the plaintiff. Yeah. We need to begin to cultivate that culture to bring some level of independence, seeming independence to the office of the Attorney General.
Right.
All right. And in the case of prosecution, sometimes the Attorney General should actually look at something and say, this one, we can't prosecute it. There's no crime to prosecute. So, when the Office of Special Prosecutor says, we have been investigating Charles Adu Boahen, and we have come to the conclusion that what he has done, though not a good thing, and may have adverse implications for his own professional life, he conducted himself in a way that is caught by influence peddling, which is very serious and is wrong. But there's no law in Ghana under which he can be prosecuted. Why should we be unhappy about that? We brought the special prosecutor here, and they insist that this is the law. Anybody else who says otherwise, that's fine, but they disagree. Let's listen to Samuel Apiadako.
And first of all, let's deal with 252, because a lot of people have brought 252, and I want us to deal with 252. If you agree with me that the first part of the offense, which is that you must have accepted a valuable consideration by either agreeing, accepting, or offering to accept. We are saying that if you look at it in that way, you might see bits and pieces of that.
But is it bits and pieces, or
yes,
actually that is what transpires?
You might see bits and pieces depending on how you situate the facts.
He says, we'll take.
Because I said that, that's why I said that the meetings were in different, if you watch the raw footage, the meetings are in different categories. The first time is that I've come to you, and then I want to establish a bank in Ghana. Then I ask you, what's the procedure? Then you give me all the procedure. Then I go into a second meeting with you and say that, well, I have $500,000 that I want to invest into the country. I want to have a footprint in the country. Who are the people that I can see and blah, 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 blah? How can you help me?
I'm a minister. I know the vice president. I know the president. I know the vice president. We can use him. He's the go-to person. He's the man in charge of this.
That is why we are saying that influence peddling is the best. You see, he's exacting his position for undue advantage. But when you want to use 252, you must prove these other ingredients that we have listed here.
Which other ingredients?
That you have unduly influenced, as you read. Now my question is that, do you have any facts to support that he has unduly influenced?
All that we have read around just this one provision, it looks like one can be caught for influence peddling.
I understand, but 252 is not on influence peddling. You see, ONCAC is as young as 2004. This provision is very old. And I've even said that even when you go to the UK and so many other countries, they are reluctant or they are failing to come up with a law on influence peddling because they said that it's so difficult to come up with what kind of influence is legitimate and which one is not illegitimate.
Is the OSP right or wrong? Relax. We are going to have him, explain to us by way of using some slides and making a presentation. So let's listen to you, teacher.
Thanks so much.
Right.
Let me just begin by literature. When my senior started with literature, let me also try and show my my love for literature. So in Romeo and Juliet, Act 2, Scene 2, I think it is, Romeo said something. Juliet said something. She said, what's in a name? That which we call rose, by whatever name, will smell as sweet. And what she actually meant is that it is not how you call the thing that matters, but what it is. Now, this leads us to what the special prosecutor is calling influence peddling. So, and we also know that at law, we don't deal with names necessarily, we deal with elements and how facts can support the element of the offense. And so whether you call it influence peddling, in fact, in some jurisdictions, they call it influence trafficking. Yes. Some call it influence trading. So it tells you that it's not the name that matters. It is the elements of what the law says that you have to look at. Yeah. So to begin with, the special prosecutor, coming up to just call it because it is called influence peddling or because they think that it is influence peddling, there's no law in Ghana which contains the phrase influence peddling, so then you cannot prosecute the person. That is the first flaw in the OSP's argument. Yeah. Now, the second flaw in the argument is that the OSP is creating an impression that those of us who think that he should have proceeded to prosecute have taken a certain position that every matter that comes, regardless of the evidence, he has to prosecute. No, I just made a point that sometimes the Attorney General must even go to court and say that, look, I agree. And you by parity of reasoning, you even added that it is possible for the prosecution to stop. So we are not here to say that anything that comes to the OSP, he should prosecute. We know that certain things may come which may not have the element. But this is something that we think has what? The element. Now let's look at the what influence peddling is. Influence peddling simply is this. Someone, is one person.
So we should hold on with the slides.
No, I will go through. Yeah.
All right.
So influence peddling is where one person, okay, gets paid or receives something of value with the task of what? Influencing someone who is in authority for abusing the law, to the advantage of a third person. Yeah. So it's like the three of us. You have given me money, and I've told you that when you give me this amount of money, or when I accept this money, Samson, who is a public official, I have what it takes to get him to do what you want. And then I accept the money, or I demand, I made a demand for the money. So that is what basically influence peddling is. It's not anything sophisticated. So now let's look at the laws that we have. And I'll just use only one law to make this point, because there are other laws that could be used.
Okay.
Now, let's go to the one you used last week, which is 252.
Yes.
Section 2521 of the
Right.
criminal
So we
offenses.
project your slide right now and we begin the discussion on it. Yeah.
Yeah. So I created this chart to make the thing, understandable.
Right.
Now, what we lawyers do is when we see a crime defining section, what we do is to break it down to what we call elements. And I'm doing this because I will pick facts from the OSP's own finding and try to fit those facts into the element to see that at least there is enough basis for the OSP to proceed to court on this. Now, this is, if you can see the screen, so the chart has columns. We have 1, 2, 3, 4, 5, 6, 7 columns. Each of the columns that we have has some particular element that you have to prove. So I have more or less disambiguated it so that you can have an easy read. So if you take one column, you have to run it, like by way of permutation across to get a clear sense of what it is. So now if we take the first one, the first one is saying that a person who then second accepts a valuable consideration and that pretense of having unduly influenced any other person in respect of function as a public officer commits a misdemeanor. What this simply means is that when you accept, something of value, money, property, house, or anything, and you are accepting it, either pretending that you have what it takes to influence a public official in the performance of his public duty, that is what you have committed a misdemeanor.
Okay. Let's correct that one. Now a felony.
Okay. Now, yeah. Sorry. Yeah. Now it's a felony because it has been revised. Yeah.
1034.
Yeah. So now it's a felony. Now, let's take the second permutation. It says that a person who agrees to accept. Here we are talking of he is not making the demand, but someone has made the supply and is agreeing to accept.
All right.
The consideration, and then under the influence of, and then it goes on. So if you look at this column 2, there are 3 options there. Whether you accept it, or 2, you have not accepted it, but you agree to accept it when it was offered to you. And the third one is, or whether you offer to accept. So you are now taking the initiative to accept. So you could see that the lawmaker captures all the possible permutation of circumstances, whether you are accepting, you are agreeing to accept, or you offer to accept. Then you go to valuable consideration. Then when you go to the 4th column, there are 2 things there. One is under the pretense of, and the second one is under the color of. Now, there's a difference. Under the pretense of is someone who actually can't do it, but he's pretending that he could influence the public official. So that is for that one. And the second one is under the color. It means that the person has what it takes to do it. So whether you can't do it and you claim to be able to do it, or you have what it takes to actually influence, is the same consequence. Now let's go to the 5th column. It says having unduly influenced, then there's agreeing to influence or being able to influence. Now again, the lawmaker has made it almost impossible for you to escape by saying that whether you have having unduly, whether you have already influenced, okay, that is one, or whether you are agreeing to influence, that is the future, or whether you are saying that you are capable of what? Influencing the person. So you see that again, there is no escape route for you even under that. Then you go to the influencee, the person who may be influenced. There we have 2 categories of person. One is a public officer, and the second one is a juror. A juror is someone who has been empaneled to determine questions of fact in a trial. So if you go, for example, and there's a juror and you go and bribe them, they'll give them something so that they will decide the matter in a particular way. The law will, will capture you. And public official, we all know anyone who is paid by the public to work for the public in any capacity is a public official. So here we have a minister is a public official, the vice president is a public official, and so on. So whichever of these happens, the consequence is that you will be caught by at least this law. Now, so you could see even from this explanation that which is called in other jurisdictions influence peddling or influence trafficking or even influence trading. Yeah. It's almost the same thing that this law can. So long as you do those things, the law will capture you. Now, I've also gone on to pick some facts from the OSP's own report.
Right.
So here we are not conjuring the facts and we are not saying what we have seen on the video. The OSP last week was making the point that they have had the privilege of
so let's get to the next slide.
The next slide. They have had the privilege of seeing everything. So we are not in the position to challenge them, but we can use what they themselves have put out as a basis to question the conclusion they came to. So now this is the second slide. And here we know from the facts, particularly paragraph 6.13 of the OSP report, which talks about the person accepting some $40,000 while the conversation was going on.
That's shopping money.
Shopping money, yeah, yes. For him to shop. Okay. So now let's go through the chart again.
Right.
Now you will see that the places that are marked green, deep green, are supposed to be places that have checked, as in there's some factual matter, some facts to support. The white places are those that have left out. Now the place that is light green is you can put, it means that any of them may apply even with the fact that OSP has. So now let's take the first, a person, in this case the former deputy minister. And we know that he has accepted the 40,000. And the 40,000 was accepted while during the conversation of this deal where he has made other demands. Yes. So my point is that from these facts, you will see that the person has accepted a valuable consideration either under the pretense that he could influence the vice president, or he has what it takes as a public official. Deputy minister is a high-ranking official in government to what? Being able to influence the vice president. Yeah. In the performance of the vice president's duty, we don't know exactly what the duty may be, but it appears the vice president has the power to decide whether the business should go on and how it should go on.
Yeah, he spoke about the fact that the vice president is very much interested in such investment, and he is your go-to person when it comes to banking, financial. In fact, he has been governor, a deputy governor of the Bank of Central Bank.
Exactly.
Right.
And in addition, I think part of the report also said that he said the vice president, because he's a Muslim and this is an Islamic bank, will be very interested in making sure that the bank, comes. So it's as if the vice president is the person who has the final say in this thing. So when you look at, we can't see the thing.
It will come back. Let's go.
So when you go through the thing, at least on this 40,000 deal, there is some basic element for this, for the special prosecutor to proceed. Okay. Now I've done other two slides. I don't know whether we need to go through all of them.
Let's go through.
Let's go
through.
Right. So the second slide, the second slide.
This is the second slide.
Sorry, the third.
The
third slide.
Yeah.
Yeah.
Right.
So the third slide is dealing with the $200,000 that he demanded as appearance fee. The special prosecutor put it as appearance fee, which means that money...
Did he demand or he suggested it? So they asked him, the guy, the interpreter of the sheikh, quote-unquote sheikh, and the interpreter here we understand is Hussein, the one who was killed, right?
Okay, Swali.
Yes, Swali, okay. Right. So the interpreter is saying, the sheikh, this is how he does his business. He always wants to know ahead of time. What is your cut? He used the word cut in the whole process. So after he agrees to the 20% share, where he says, look, I also have an estate company, real estate company. And the manner in which you can do is that if you brought the money, you could decide to, do something in the real estate business. So we are doing affordable housing projects. You can bring it through that process and then you get I'll get some percentage in it. You decide to build, if you want to build 1,000 houses, for example. And I'm using specific expressions that the two of them engaged in. Then after he said, well, so what's your percentage? What would you take? He said, well, he's not in a position to do that. He said, as for the sheikh, he wants you to say it yourself. How much? Then he said, okay, let's say 20%. Then he brought in the vice president, and they said, so what will be what should we prepare? Either he is meeting us or we are meeting him. Remember, he tells them that the vice president was supposed to be with them, and then they'll go to Singapore, but the vice president was unwell, so he couldn't come. Then he says, so what do you mean? You mean like an appearance fee? This is Adu Boahen speaking. You mean appearance fee? And they said yes. That's where he said, well, if you give him some $200,000, he'll be fine with it. But his interest is in bringing, as it were, investment to Ghana. And when you bring it, this is the way to do it. Once you see him, he has a large family. He says 6, 7, or 8 or thereabout. You let one of them be part of the family, the business. So that's what went on. Yeah,
so clearly, there is no official requirement that if you want to see the vice president, you should make some payments called appearance fee. Yeah. And if there is before you charge any money like that, you need law. Law must back it. Yeah. And that's why we have fees and charges, whatever, act. Yeah. So clearly, this money is not a lawful demand. But whether he suggested it, this is the provision. It says offers to accept. That is a phrase used by the law, offers to accept. So clearly, he is offering to accept that money and even putting the vice president to, his name is into disrepute. But let's leave that other side. So when you take the 200,000, when we run through the chart again, you will see that a person has offered to accept a valuable consideration, which is the 440,000, under the pretense of being able to influence the vice president to perform his function. So again, if you run even this one through, it appears there's some prima facie
But that money was not conditioned on bringing the vice president or giving them access to the vice president. That money was not asked for. The 40,000, he didn't ask for it. They just dropped it in his face.
Well, so we finished with the 40, but he accepted it in the process of. You see, these matters are matters for the defense to raise.
Okay.
For you, the prosecutor, you have to make your case that, look, he has taken this money, and at these elements, of course, the fact that we are having this discussion doesn't mean that the deputy minister, when the matter goes to court, will be guilty.
Okay.
There are so many things that he has to show. He has to explain himself, he even has to justify, but that job of justification is not for the special prosecutor to perform. And appears, last week, I think he himself, Sami, my very good friend, he himself seemed to accept the fact that they are looking. And he said they are beginning to look as if people are thinking that they are even defense lawyers for the person.
Yeah, which is very much the case.
Yeah, you are not supposed, as a prosecutor, yours is to establish what we call a prima facie case. And the defense will always have. So the conversation is not to say that the deputy minister is guilty. So again, here we have it. Now, when we go to the other slide, which that deals with
that's the last. So let's quickly get to that. Yeah,
and that deals with the 20% of the value of the investment.
Right.
Which again, he made the offer to accept. He made the offer to accept, and then under the pretense or color of his whatever, and in the same vein of being able to influence the public official to do their work. So with all this, it becomes very difficult for me. Even as a defense lawyer, okay, I have never prosecuted anyone before. I don't think any of us.
We only defend. Yes, we can't.
Yeah, we have not worked for the state before. But even for defense lawyers as us, we will hit you that if this is not enough to start prosecution, then what will be? And now this leads me to something. You see, sometimes we just need to sit back and reflect over the job we have been given to do and why the office of the special prosecutor was even established in the first place. Sometimes maybe we are too much into the details and we forget the bigger picture. Imagine this statement that the OSP has issued. Basically what it means is that everyone in Ghana now can go ahead and do things like this and there's nothing wrong with it.
No.
What?
No, the OSP says you have engaged in influence peddling. It is serious.
Yeah.
And as far as the OSP is concerned,
Yeah.
this is an adverse report about him.
Yeah.
It doesn't bode well for his professional career going forward.
Yeah, but you see, there's something called prisoner's dilemma. Okay. For a criminal or someone who wants to commit a crime, his thought is clear. He's weighing the cost and the benefit of, if I'm going to get 20% of how much billion of dollars?
500 million.
And you are talking of what?
So
my
$100
reputation.
million.
Yeah. You are talking of my what? Social reputation, which that money can buy millions over.
And churches will even give you front seat,
So, you see,
chairman, elder.
So the report is actually promoting this report. The ultimate effect is to promote exactly what the special prosecutor claims is supposed to prevent.
I need you to wrap up in a minute. Does Ghana have laws to prosecute influence peddling? What happened? Was it influence peddling?
I have no doubt in my mind that what happened, our laws, prohibit that and prescribe punishment for that. As to whether you decide to call it influence peddling, influence trafficking, influence trading, or what, anything that you want to call it, that is your choice. But as far as my understanding and reading of the law is concerned, I have no doubt in my mind that even by his own report, the OSP's own report, there is enough facts in that report to at least commence prosecution, and that is no persecution, that is no witch hunting, and that is none of the things that were being made to believe.
I'm going to Martin, but does it matter if in such a prosecution it is mounted and Anas, who produced this documentary, is not willing, is not available to be a witness for the prosecution? Will it be material?
Well, I mean, it depends on, I am not seized with the entire facts of the case, but if what we are having here, we have, when we say documentary evidence, it also includes video.
Yes.
So the admissibility of the video may be an issue, the weight of the evidence may be an issue, but I don't think that the availability of the what do we call it? The investigator would necessarily, demolish the case.
Okay, interesting. And I asked that question of him because Anas has become endangered particularly after all the Kene Japan stuff and then the judgment that was issued. He's become endangered. And people insist that if there must be a court process where he is involved, he must show his face. They will not allow him to come there, cover his face. Previously, he used to go to court and be a witness for the state without showing his face. And many people have been jailed. Customs people, call it Osu Children's Home, all the rot that went on. He has helped to punish people, but he never showed his face. But now there's been a crusade that if he must be in court, he must show his face. So for you, let's start from there. Does it matter? Is it material that he will not be available if the OSP wanted to prosecute?
It matters a lot, certainly. But I thought from what we are told, okay, so it's assumed that he was in there. So he must because, he did the work. So naturally, if there are questions, it's just like when you send a medical report to court and you don't bring the doctor, your case is almost going to die if everything hinges on that report. So in this case, since he was involved in getting the video, he has to testify. And on the matter of showing his face, I subscribe to the situation where he will show his face, but in camera.
Before the judge?
Yes.
The lawyers, the parties, and the judge?
Yes, because
not in the courtroom?
Not in open courtroom. I've done cases like that, and when I say cases right now, I've been doing some research in that area. In the UK, they've done, they've even gone to the extreme, and now they regret it. So, and if you look at it, some of the extreme is like the way Anas will testify without showing his face. No.
I've done one matter in which Manasseh, he's public, everybody knows him, but his security was in danger. The judge agreed for Manasseh to come to the court through the judge's entrance.
Yes, so that's how it's supposed to be.
Through her chambers.
Yes, so that's how it's supposed to be. And we now even have the anonymous witness law, witness protection law, blah, blah, blah. So he should be able to show, but in camera.
But what is your verdict on this matter?
Oh, absolutely. This one is influence peddling. And OSP, Kise Jabin himself, under his hand, he says that's influence peddling. But where he got it wrong was where he said there's no law. It's possible escape team. It's possible because you know what? You see, like even Samida who came here last week and he was saying that in the UK, what was the phrase he said? He said that there's no law, they don't prosecute. But I have...
says they are hesitant.
Oh, but you see, listen, lawyers who practice criminal law, they know this Blackstone's criminal practice. You know, this is 2018. You go to page 922. This is there, under their bribery act. This is what the authors write. That if P offers a financial or other advantage to R, who undertakes no relevant functions or activity, so that's Adu Boahen, on the understanding that R will then seek to approach and influence a third party, S, who does, the criminality of P's conduct under Section 1 will depend on blah, blah. Then they show the various. That's influence peddling, straight. So when I hear there's no law, UK, they are reluctant, or some have even said there's no law at all. It's blatant falsehood under their bribery act. Yeah, and that's Blackstone's criminal practice. Yeah, the professor at Oxford. These things they've been writing them. If you take Archibald, you will see the same. So it's clear that for influence peddling, and I like how Srem Sai mentioned it, it's not about the name, it's about the substance. The substance is clear that A, okay, offers to B, that take this one CD so that you can talk to C for me. And it's not always about money. Yes, when it doesn't always have
valuable consideration.
Yes, valuable.
Anything of value.
You see the building one. So it can be that if Sam is the person that I'm giving, so assuming, so I reverse it. I'm the one giving money to Sam. So no, I won't give Sam money. Sam, I'll say, look, I have buildings at Trasaco. It's $500,000. You know what? For doing X, Y, Z, I'll offer it to you at $150,000. So I shave off what? $350,000. That's valuable consideration. You don't need to. I don't need to give you money. And that's even far. It can also be different things. Maybe, Sam, you are holding $500,000. You want to buy. But that's the only property. So many people are buffeting me here and there that they want to buy. But because I need you to do the influence peddling, I say, okay, Sam, you are the only one I'll give this offer to. The 10 other people should go. You see, yes. So even for offering that opportunity, because there are 11 of you struggling for that thing. So even to sack the rest and tell you that you are the one I'll give. So even if you give me $500,000, which is the market price, because I sacked the other people because I wanted you to see Srem Sai for me. So there's still influence peddling. It doesn't matter that you've given me the market value. You got the offer through illegal.
As we understand, this was something they had started, but certain things happened, so this couldn't be completed. It couldn't be consummated.
Okay.
The setting up of the bank in Ghana, and then the monies and the percentages that would have been enjoyed, none of it happened.
Yes. Thank you.
Does it matter?
It doesn't. And Sami himself, I was on TV3, he brought in that question. Inchoate offenses, conspiracy. As we sit at this table, if we hatch a plot that we want to harm Amiesi, Srem Sai will bring a dagger, Sam will bring DDT, I will buy a rope. Then we say 9 o'clock, we invite her, we are going to a club, blah, blah, blah. We will kill her on the way. If the evidence is captured, we've planned the offense. Conspiracy to commit what? Murder. Straight.
It doesn't matter that we haven't done it.
At all.
It doesn't matter that we said we'll do it at 3 p.m. and at the time we're being arrested it's 5 p.m. and Mamisi has not been harmed.
Excellent. At all. I like your example. Bring another one. The most important thing is that we planned it, we're serious, we're not joking. You know, I'm just looking at every law student, every lawyer to remember the case of R.V. Ochre, the case involving the coup d'etat those days, Obeche Bilamte, Ochre, when they were planning to overthrow Kwame Nkrumah. A popular case. It's a conspiracy. Oh, define it and make it clear. Chain conspiracy, wheel conspiracy. Yes, the most important thing is that you planned. It wasn't a joke. If we are not joking and we really mean it, we are going to harm Amiesi. We get all the accoutrements.
What should happen now?
Look, one thing very, very clear. Mr. Kisi Ejabin should eat humble pie. Look, as lawyers, we all make mistakes. That's the nature of the practice. That's why we say we're always learning. We make mistakes. This one, perhaps they were looking for the headline influence peddling and they didn't find it. I know, the office, there's so much pressure. I think this is a clear mistake, very clear. So he should eat humble pie.
You cannot be saying mistake. They say that they have come through the laws of Ghana. They didn't say just their laws, the laws of Ghana. And there is none to be used, even though Sami says there are bits of that in 252.
And it's not just bits. 252 is the law. I mean, we've checked with most lawyers who know something about this. 252 is very clear. Look, you should accept that it's a mistake and recall his report and do the needful. Otherwise, look, I was just talking to Srem Sai. We will go to court. Sam, I'm telling you, we will go to court. This conversation will not end here. No. We have to go to court. Let the courts decide. So we will look at either suing him for judicial review. I mean, we will look at it. But what I'm certain about is that the conversation shouldn't end on the TV shows. And no. Because we all have a stake in this. Adu Boahen can't go home or he can't keep that $40,000 forever. But now, that's why I mentioned that OSP should have ordered him to return the $40,000. He should ask him to return it, pending further action.
But that money, Justice, that money and other crimes that may have occurred, like, what do you call that popular one? Money laundering. And at the airport too, when you are coming in with money, you are supposed to, what you don't declare is less than 10,000.
Yeah,
so if you brought all of this money and didn't declare it, and it appears he didn't declare that money, so there'll be money laundering and other things. That's not for the OSP.
Yes, so what it means is that other state agencies should also get work. Because, I mean, that is what...
Let me mention that. I did a case
so you should not be asking that the OSP should ask for the money or detain the money.
Yes, because we sit as exhibit in the trial. I did a case recently on this one you are mentioning.
Which trial? Because it says it is not able to try him.
Oh, now we've shown him that he's wrong. And he has to eat humble pie and do it. He himself has already concluded that it is influence peddling, except he didn't see the law. Now the plurality of lawyers, majority, we agree that no, this is the law. So let's go with it. So that's how it should be easy for Kisi to do it. And then the one you mentioned, I won a case recently on this bringing money in. The Court of Appeal says that, look, don't charge. It's for the GRA boss. So the GRA boss would then put in administrative penalties. Okay. Yes, when you bring in such money beyond the $10,000, a client of mine was prosecuted. High Court, we appealed, went to Court of Appeal. The Court of Appeal said, no, the charges were wrong. It's to be dealt with administratively. So the GRA boss will do administrative penalties. And then so Adu Boahen can't keep that man. That's why I'm saying, look, that's not Kisi. We need to motivate Kisi Ejabin to get up and do the needful. So this also means that GRA boss maybe will send a petition to him to ask Adu Boahen. So he should ask for the penalties. Kisi's letter too should go to Adu Boahen to bring the money. Yes, we can't do this. Otherwise, this will be a banana republic. Tomorrow they say you and I, we didn't work hard. If we allow Adu Boahen to keep this money. there are many other things like that going on. If we sit down and allow this thing to fester, tomorrow they say, because we went straight and narrow, right? Yeah, so that's why we all have a stake.
Justice wants to say something.
My biggest concern is the precedent that this is setting, even in our investigation of the precedent that this is setting. We cannot leave the impression out there that doing something like this can happen without any consequences, any criminal law consequences. Now people are going to trade in influence without any restraint on their mind, and they will do it publicly without any regret whatsoever, knowing very well that there is a state agency which is supposed to fight corruption, the latest, the newest of the agencies, and the one that is supposed to be the most ferocious, is saying that, there is no law prohibiting this, so you can do it. Yeah, it's just a moral issue. People may find it very unpleasant, but there's nothing that can happen. And that is my concern, that is my worry, that it should never be so that something like this, when there are clear laws on this, and then we leave the impression out there. So I think Mr. Kisile Jabin needs to do what is right. I think the work is hard. I mean, we are all lawyers. Sometimes we go to court and we make some of these oversight happens. Yeah. So now that your attention has been drawn to this, I think it's just the right thing to do is to look at it critically and then take some steps. And that is not to say that the former deputy minister is guilty. No. I mean, like Kisi keeps...
Yeah, you are repeating this the second time.
Yeah.
That's very good of you.
It's a very important point that the fact that we are saying all this doesn't mean that he's guilty, because there are so many other things that can happen in a trial. And he has his side of the story and to explain to the court, and the court will take other factors into account. So we shouldn't make it look like there is some, determination by some people that he should be in jail or he should do. No, he can defend himself. But what we are saying is that we cannot keep a system, or this report cannot stand and create the impression that you can do all this without any consequence.
Yes.
Martin, so how can you say this is a slip, an error, a mistake, and so he should go back and take this and get to court with it? It cannot be that light.
Yes, I get you. I know. To be honest, yeah, there's a part of me that thinks that, look, it's not a slip and the rest. But, when we go into that realm, a lot of sociology will come in. The reasons why it's not an error and all that is deliberate. So because that path is very slippery, I prefer to come and say it is, so that I don't have to when I give reasons that we all make mistakes, it's more, acceptable. But if I think it's deliberate, to be very honest, we'll all then begin to think of corruption. I'll be very blunt. Yes, we'll begin to think corruption. And of course, he's human. And we hear things. I won't lie. It's better we start, because he's also human. He's not an angel. And so he has to know that we also hear things and all that. But I don't want to go down that path, right? Because we all want to support him. So it's better for me to choose the path that is a slip. And so a slip, we all make mistakes. As lawyers, we make mistakes. So he should just come back. And let me mention to you, apart from he saying there's no crime on influence peddling, let me mention, apart from 252, I'm looking for the one that says don't influence parliamentarians in their work. It's also influence peddling. There is common name, lobbying. Lobbying is a species of influence peddling. Yeah, I'm just trying to look for it. There's a provision that don't influence parliamentarians in their work. So that thing. It's also, so in Ghana, we have criminalized it. Elsewhere, lobbying is allowed.
Is it about politicians or the provision in our constitution that talks about a public officer should not put themselves in a way that will conflict of interest, or conflict with their...
Not that one. There's a specific one on Parliament.
Okay.
Quickly, there's one on Parliament. Don't parliamentarians in going about their work, we are not supposed to lobby them. Yes, it's one law that we've been, they openly say, lobby so and so, lobby so. Oh, it's an express provision. So, it just clicked me right now. I'll get it.
So when you go
but this report is adverse, it's bad for him. Why don't we consider that too as well? Must it be prosecution alone?
Well, it's bad for him, but that is morality. We can have another conversation on the moral effect of what has happened. But now, I think the conversation is the legal aspect, the criminality of the matter. So obviously, nobody wants to be walking around with such news items hanging on your head, and it doesn't give you an opportunity. We were just discussing these companies could think.
Correct.
Now, the difference here is that the morality bit, he would pass as a director of a
company.
Yeah. Yeah, that is what it means. Yeah. But if the prosecution succeeds, then the intention of the framers of the company's code section would now come in. And let me make the point. When you read the criminal laws, generally they criminalize this influence, not just so you see that there's one for legislature, then the juror one is about the
juror duties,
the judiciary, and then the public official one is for, so really the framers of even the drafters of this law had in mind all public officials in various capacities. So it cannot be that this can happen and there is no crime committed.
All right, Martin, what will be your final words then?
Yeah, so I want to repeat again that Mr. Jabin should just eat humble pie.
He should withdraw the report.
Yes, he has to, because otherwise, well, we will go to court. We will have to.
You go to court to compel him
yes.
to prosecute?
No, the investigation. So in this particular case, yes, so we are aware that to prosecute is quite a high bar. But this particular, he himself said, this has been lowered. You know, to every rule, there's an exception. In this case, he said there's influence peddling, except that there's no law. So when you go to court and the court agrees that this is the law, I think it can be done.
Thank you very much. Martin Pebu is with GT Legal Africa, and he's a rights activist. Dr. Justice Srem Sai is with Praetorium Solicitors and is senior lecturer at GIMPA Law Faculty. You want to say something? Maybe you can say it.
Yes, quick one.
15 seconds.
Going to court will not necessarily be to push him to, of course, prosecution. If he doesn't want to, you can hardly do something about it. But, you know, there are grounds for removal from office, and one of them is incompetence.
Okay.
So, depending on what the outcome of the court decision may be, it may lead to something else.
All right. This has been The Law. It's your legal light. It's your health law. I'm Samson Lardy Anyenini. Thank you very much for your company. Join us next week for another edition.